joining us for this webinar, this Red Lion Chambers webinar, which is Stages in the Life of a Public Inquiry. Now, public inquiries seem to have gained increasing prominence over recent years, and they have addressed topics as wide-ranging as systematic child sexual abuse, transport accidents, fires, infected blood, undercover policing, the mismanagement of pension funds, self-inflicted deaths in custody, decision-making that has led to war, and now, possibly, the outbreak of disease and the management of a major pandemic. But what is a public inquiry, and what actually is its purpose? Well, in short, a public inquiry is an investigation. The only requirement for a public inquiry to be convened is that there be public concern, a serious public concern over an issue. And that public concern needs to be significant enough for an inquiry to be initiated and funded by government. But once set up, inquiries are run independent of government. So what's the purpose of a public inquiry? Well, it's now generally accepted that a public inquiry considers three key questions. What happened? In other words, they establish the facts, though not always. Why did it happen and who's to blame? So a public inquiry will look at causation. What can be done to prevent this terrible thing from happening again? So looking at lessons learned and future prevention. But in terms of how those questions are dealt with, in terms of the ethos of an inquiry, the way it's run and how it approaches its investigations, that will vary from inquiry to inquiry, and much will depend on the people involved. Who is appointed as chair, what their background is, and what the constitution of the legal team that sits behind the chair is, and the decisions that they collectively make at the outset. So this webinar, which is aimed at those interested in learning a little bit more about how inquiries work, is designed to take you on a whistle-stop tour of the different stages in the life of a public inquiry. And it's drawn from our respective and very different experiences of inquiry work. So who are we? My name is Riel Karmy-Jones, QC. I'm in practice at Red Lion Chambers, and I was senior counsel to the Independent Inquiry into Child Sexual Abuse, or ICSA, between 2017 and 2019. I'm joined by Emma Gargitter, also a colleague from Red Lion Chambers, who was junior counsel to the Al-Swady inquiry between 2014 and 2010, sorry, Emma, and 2014. And she's also been on the other side of the divide. She's advised a witness during the Maxwellization stage of the Chilcot inquiry. And she's presently junior counsel to the Undercover Policing inquiry. And we're very grateful to Richard Scorer for coming on board and helping us with this webinar. Richard is head of abuse at Slater Solicitors. He's a specialist in public inquiries and has represented many core participants over the years, including many survivors of clerical sexual abuse. Richard was heavily involved in ICSA, and so whilst Emma and I will be discussing inquiries from the perspective of those who run them, Richard will give us something of the perspective of the core participants, those on the other side of the inquiry. So we're going to begin with Emma, who's going to discuss how an inquiry is set up and the early stages of an investigation. So you know what's coming. I will be looking at the hearing itself, the steps before and after the hearing as well. And Richard is going to, in effect, respond to each of us and will give us the other side of the coin, the other side's perspective on the topics that we raise, and some insight into how core participants approach the different stages of the investigation. At the end, if there's time, and apologies in advance if there isn't, we will take questions if there's time, which we'll select from any messages posted. So I'm going to kick off with Emma, over to you on setting up an inquiry. And I think Richard and I can turn our cameras off or or mute ourselves while that's going on, so as not to distract.
Thank you, Riel, and hello, everybody on Zoom. So I've got the early part of public inquiries to speak to you about, and I'm going to split it into 3 stages. First, the setting up of an inquiry. Second, what happens when the inquiry starts work. And thirdly, addressing what is often one of the biggest phases of an inquiry, certainly in terms of time, that is the investigation itself. So an inquiry setup. It's important for me to say at the outset that what I say today is focused almost entirely on statutory inquiries. That is an inquiry set up under the Inquiries Act 2005. There is such a thing as a non-statutory inquiry. They existed before the 2005 Act, and they exist now. They can still be set up, and the Chilcot inquiry into the Iraq War was an example of a non-statutory inquiry. Arguably, they provide some greater flexibility in terms of procedure and process, but the main and probably most important distinction is that they don't have powers to compel the provision of evidence, which a statutory inquiry has. And that's what I'm going to focus on today. So what happens first when an inquiry is set up? Well, somebody has to be put in charge. And it's Section 3 of the Inquiries Act that specifies that a public inquiry can be undertaken by a chair alone, or a chair and one or more other members, which are known collectively as a panel. The minister who sets up the inquiry appoints the chair and any panel members, but only after consulting with them. So it's not something that is imposed upon those who participate, but something that they agree to. There is no requirement in the legislation that the chair of a public inquiry should be a judge. There is some provision in the Act to guide a minister about who to consult if the minister is proposing to select a judge. So it does rather suggest that the Act has in mind that it will be a judge, but it doesn't have to be. Practice is that it most often is, but ICSA is a prime example of an inquiry that certainly in its latter phases and currently is not chaired by a judge, but has a panel led by a chair who is not legally qualified. So that's putting somebody in charge. When does a public inquiry actually commence? It's not as straightforward a question as you might imagine. In fact, the Inquiries Act specifies or requires a minister to specify a setting up date for an inquiry. It has some significance because an inquiry cannot consider evidence before its setting up date. So it can have a chair, but it can't start considering any evidence. Another thing that's required to set up an inquiry are some terms of reference. The terms of reference are key to the scope of the inquiry. They are set by the minister who sets up the inquiry, although the minister is required to consult with the chair or the panel, whichever has been appointed. So it's a process of consultation between the minister and the chair in most cases, which results in the terms of reference. There is no specific provision in the legislation for any wider consultation, but equally there's no prohibition on it. And so inquiries, for example, such as Grenfell, have consulted more widely. So Grenfell appointed its chairman, a week after launched a consultation on the terms of reference, and about 6 weeks after that formally announced its terms of reference. So during that time, the inquiry hadn't officially been set up, but the terms of reference were consulted on. As I've said, they set the tone for the whole inquiry. They are where the inquiry team finds its instructions as to what it's supposed to do. And the wider the terms of reference, generally speaking, the longer and more complex will be the investigation the inquiry is required to carry out. Narrower terms of reference are more likely to lead to a more focused and quicker inquiry. But it's a bit of a chicken and egg situation because the terms of reference are necessarily set right at the very beginning of the inquiry before any evidence has been considered. And so often wider terms of reference seem attractive at the outset because it's difficult to be precise about which are the most important and significant issues that the inquiry ought to consider. There is provision in the Act for the minister to amend the terms of reference. but it's rarely used, and certainly it doesn't seem to be used regularly to refine terms of reference as an inquiry goes along. Often the terms of reference will set a target date for the inquiry to finish. Again, that's not something that the legislation requires, but it's often done. There's a big question, in my view at least, over the utility of doing so. And I'll give you perhaps the most stark example as to why it may not be something that realistically can be forecast at the outset. The Bloody Sunday inquiry lasted 12 years. When it was set up under earlier legislation, it was forecast that it would last for 2 years. Just a couple of other considerations to bear in mind when thinking about the scope of a public inquiry and what sets the scope. It's important to remember that a public inquiry cannot determine any civil or criminal liability. Section 2 of the Inquiries Act forbids it. Although an inquiry can reach conclusions that might be relevant to whether there is any civil or criminal liability to attach, it can't determine that liability. And the second thing to bear in mind is where a public inquiry is set up to be the independent and effective investigation by which the state is complying with the requirements of Articles 2 and 3, or 2 or 3, so where there has been, for example, a death at the hands of a state agent or involving the state, then additional considerations will apply to ensure that the public inquiry fulfills that important function. The terms of reference will usually set that out, but not always expressly. So that's the setting up of a public inquiry, and that follows a relatively uniform process in the case of each public inquiry. But as Riel has mentioned in her introduction, essentially each public inquiry is a new and independent body, and therefore what it does thereafter can vary quite considerably. So stage 2, the inquiry starts its work. Before it can start work, it needs a team. Beyond the selection of the chair or a panel, the legislation provides relatively little guidance and rules on how an inquiry team should be made up. So each inquiry sets itself up from the start. Commonly, there will be a team which includes a solicitor to the inquiry, who will instruct counsel to the inquiry, and a secretary. And I'm going to address those 3 core roles on the inquiry team briefly to give you an understanding of what they do and who those teams are. So firstly, the secretary to the inquiry, that's a role that those involved in litigation outside of the public inquiry world might be unfamiliar with. The secretary is conventionally appointed at the outset by the chair. It's a role that is defined by the Inquiry Rules 2006 as a person who is appointed to carry out administration and management of the inquiry. And so that means they're responsible at the outset for finding accommodation for the team, includes IT and other equipment. They are responsible for the budget and forecasting of how long the inquiry is likely to take. They are responsible for all the admin that's linked to holding evidential hearings, so finding somewhere to hold them, making sure the witnesses know where they're going and things like that. And at the end of the inquiry, they're responsible for archiving what's called the inquiry record. So all of the material that the inquiry has gathered together and made public has to be archived and kept publicly available. Another important function of the secretary is to liaise with what is by then known as the sponsor department. So that's the government department that set up the inquiry, becomes its sponsor because it's providing the money. And the secretary has an important function liaising with the sponsor department in order to agree that budget. And a quick look at inquiry websites will show you that the budgets of different public inquiries can vary quite widely, even between public inquiries funded by the same government department. And that's another reason why each inquiry will be different from the next. Briefly then, solicitor to the inquiry as another one of the core roles. Again, usually appointed by the chair at the outset and must be a qualified lawyer. And will inevitably have a team of solicitors working with him or her. The solicitors team is generally responsible for managing how the inquiry carries out its investigations. Document management is an important part, and the disclosure process generally, which is documents coming in, but also documents going out to the participants. An important role in liaising with the inquiry's core participants and witnesses. And the solicitor will also have a role in assessing costs where funding awards are made. And I'll come on to that very briefly later on. And then the third aspect or core part of an inquiry team, the counsel team. An inquiry never has to have a counsel team. And the Chilcot inquiry was an example where there was no counsel to the inquiry and indeed no legal experience on the panel, but often counsel is appointed. Similarly, counsel to the inquiry, the lead counsel will be appointed most likely by the chair at the outset with a team to follow. And the primary functions of counsel to the inquiry, much like in any other case, providing advice along the way. That can be quite wide-ranging as to the process and procedure adopted by the inquiry, because the legislation in fact provides some rules, but by no means all the rules required. And so a lot of an inquiry procedure or process will be determined by the chairman with advice from counsel. And counsel are also responsible, as Riel will come on to address later, for the bulk of the advocacy at the evidential hearing. So they ask most of the questions of most of the witnesses in most inquiries. In practice, and perhaps one aspect of public inquiry work for lawyers at least that's quite different from other forms of litigation, for example, is how closely counsel and solicitors to the inquiry can end up working together. There can be quite a lot of interchange between the roles and quite a lot of close working, often at the same premises together at the same time. It's worth noting, I think, at this stage that the legislation, the Act and the rules are largely silent as to the allocation of tasks as between various teams in an inquiry, although there's some guidance provided. And in particular, what the inquiry legal team, the solicitors and counsel, should be doing, as opposed to what is the chair's or the panel's responsibility. Obviously, core decisions will be left to the chair, but if the chair had to take every single decision, or the panel, they would most likely quite quickly become overburdened. So it's common practice, in fact, that counsel and solicitor to the inquiry will take a number of decisions along the way, if by a sort of informal delegation from the chair. And that's another aspect in which inquiries can differ, because it will most likely depend on the chair or the panel how much control, how much work they want to do to take those decisions. But as I say, of course, any core decision that will have a significant impact on how the inquiry proceeds will be left to the chair, who, should there be a JR, will become the defendant. So in addition to the inquiry team, when it starts work, an inquiry will most likely look for what are referred to as core participants in the legislation. And those are essentially the people, the individuals, sometimes groups, who are to be given rights to participate in the core aspects of a public inquiry. It is worth noting that you don't need to be a core participant in order to give evidence or otherwise engage with a public inquiry. It can be relatively informal, but what core participant status brings are additional rights of participation that the legislation provides. So first, what's the test to become a core participant? That's set out in Rule 5 of the inquiry rules. And it has three limbs. It's someone who played or may have played a direct and significant role in relation to the matters to which the inquiry relates, someone who has a significant interest in an important aspect of matters to which the inquiry relates, or someone who may be subject to explicit or significant criticism during inquiry proceedings or in the report. An inquiry can only designate someone who consents to being a core participant, so it's not the inquiry's decision entirely. It has to be a volunteer. And if a core participant, once appointed, themselves appoints a lawyer to act for them, then the legislation provides that they must be designated as what's referred to as their recognised legal representative. So a CP is effectively entitled to legal representation under the legislation. There is a provision, which I think Richard might address in due course from core participants' perspective, which allows a chair or panel effectively to group or corral core participants under one recognised legal representative, with the aim effectively of reducing the cost of having multiple participants and multiple lawyers. I should say that, in fact, anyone who's required to give evidence before an inquiry, whether a CP or not, can have a recognised legal representative. The main rights then that come with being a core participant are as follows. It enables you to make opening and closing statements at the inquiry hearings, and that's so whether or not you're represented. So as a core participant, you can make an opening or closing statement in person if you choose to. You can apply to ask questions of any witness who gives oral evidence. As Riel will come on to address later, the legislation is quite tight as to who can ask questions at an inquiry. So that's a pretty important right that you get as a core participant. And as a core participant, you're also entitled to a pre-publication copy of the report. So you get to see what it's going to say before the world does. The Inquiries Act and the rules provide a system for funding to be granted to core participants and also to witnesses, subject to their financial resources and a public interest test. And Richard may come on to that aspect in due course from a core participant's point of view. Ultimately, the solicitor to the inquiry will assess the awards that are to be granted. The number of core participants is quite a key factor in a public inquiry because it's likely to affect the length and complexity of a public inquiry. To put it shortly, more core participants is likely to mean a longer inquiry, and fewer core participants a shorter inquiry. Another early aspect of inquiry work, once the team is in place and those who are affected have been identified and awarded core participant status where they meet the test, is to plan the investigation, or in other inquiries, sometimes it's referred to as a list of issues that is produced. And the purpose of this is to tell the world what the inquiry team really thinks it needs to do in order to meet the terms of reference. Sometimes it's a list of questions that the inquiry team consider should be answered. Other times just a list of issues. And sometimes, for example, as I understand it in ICSA, it was expressed as a number of different strands of investigation. It's not required under the legislation, but it's seen as good practice to make sure that everybody understands what the inquiry plans to do. It may be an important stage in the inquiry for participants because unless there has been consultation on the terms of reference, it's the first time potentially that participants will have a chance to make submissions as to how the inquiry should approach its work. There may also, I'll just touch on this very briefly, there may also be preliminary hearings to decide preliminary matters of procedure, such as what standard of proof the chair or panel should apply when they come to consider the evidence. The final stage I'm going to address is the investigation stage of the inquiry. It's commonly overlooked that one of the primary functions of a public inquiry, as Riel has said, is in fact to investigate. Oral hearings of witness evidence come after relevant documents have been identified and analysed. And although that tends to be what attracts most publicity, it's often not the longest or most intensive phase of the inquiry, certainly not for an inquiry team. First of all, the inquiry team will need to figure out where the relevant material is. Although a public inquiry will often follow some other sort of less formal inquiry, such as a police investigation, possibly disciplinary processes, it doesn't follow, at least not in my experience, that all of the material is happily filed somewhere in a series of boxes or on a document management system that can be easily picked up and accessed. And so a lot of time and effort is likely to go into finding documents, who holds them, obtaining them, and organising the material. A public inquiry will also want to assure itself that those it is investigating, which is most often state parties, given the nature of public inquiries, it will want to assure itself that they have taken reasonable steps to preserve information and to identify any obvious gaps. it's usual for the solicitors and/or counsel to the inquiry to draft a disclosure protocol, setting out what is expected in terms of disclosure and what it will do to disclose material. And here is where the Inquiries Act gives a power to compel provision of evidence. Section 21, it can issue a notice compelling parties to provide it with evidence, subject to certain exceptions. Failure without reasonable excuse to comply with such an order is a criminal offence, triable summarily only, contrary to Section 35 of the Act. It's a power that, in my experience, is in fact used relatively rarely, because more often than not, state and non-state parties who are engaged with the public inquiry are willing to provide material without a formal request of that nature, but it's useful in certain circumstances. An inquiry can't compel the provision of material that a court couldn't compel. So, for example, it can't defeat a claim to LPP using that power. The inquiry, having got all the documents in the door, will then have to review them, identify potential witnesses as early as it can, manage its documents with a view to disclosing them out to the participants ready for the hearings in due course. And that work is likely to be done by the solicitors to the inquiry, counsel to the inquiry, or most likely a combination of both of those teams. Relevance of any of the material and what use is to be made of it in terms of disclosure is really a question for the inquiry team, ensuring effective participation in the inquiry and fairness, which is the ultimate test really in an inquiry as to whether something is fair, determines whether or not it's the right process to follow. Another thing the inquiry will do in its investigation phase is send out requests for witness statements. Rule 9 of the inquiry rules makes it obligatory for an inquiry to send a written request for a written statement to any person from whom it proposes to take evidence. It must include a description of the matters or issues to be covered in the statement. That's it in terms of guidance. So the format of a Rule 9 request for a witness statement varies considerably from inquiry to inquiry, but also sometimes from witness to witness. There is a balance to be struck between ensuring that a witness comprehensively addresses the questions which are of interest to the inquiry and the significant issues the inquiry is looking at, and ensuring that they're not overburdensome for the witnesses who have to answer them. What, if any, disclosure of documents is given to a witness with their Rule 9 request is likewise a matter that's really within the discretion of each inquiry and can vary from inquiry to inquiry. If you're asking a witness to remember events many decades ago, it's likely they're going to be greatly assisted by any contemporaneous records that the inquiry holds. On the flip side, what is not a good idea to do usually is to provide the witness statements of other witnesses who are going to give evidence, because that might, however inadvertently, contaminate their evidence and thereby undermine it in the inquiry. So there's a balance to be struck for all inquiries. Who takes the witness statements? More often than not, the witnesses are legally represented and their lawyers will take them. If they're not legally represented, the inquiry legal team will step in and do that job. Finally, before I let Richard have a say on behalf of the core participants, I'm just going to address briefly restriction orders. It's quite a controversial part of the Inquiries Act legislation. Public inquiries, as Riel has said, are by definition set up because of public concern, and understandably, therefore, the Act at Section 18 imposes a duty on the chair or panel to take such steps as the chair considers reasonable to secure that members of the public can attend the inquiry or see and hear a simultaneous transmission of proceedings, and to secure public access to evidence or documents given to the inquiry. So it's not an absolute right to disclosure, but it is set out in the Act that the chair or panel should take those steps where they're reasonable. But Section 19 of the Act permits restrictions to be placed on disclosure or publication of information that's been provided to the inquiry, and attendance by person at inquiry hearings. So it follows that although a public inquiry should aim to be public, it's possible, if the tests in Section 19 are met, that parts of it might have to be heard in private or indeed in closed hearings, excluding the majority of its participants. Just very briefly, in what circumstances can restrictions be made? It's all set out in the Act. They're relatively limited grounds, but they include, for example, it being necessary in the public interest, which is one of the more commonly relied on grounds. Also, if it's conducive to the inquiry fulfilling its terms of reference is another basis on which a restriction could be made. The chair or panel is directed to have regard to certain factors, including, as you might expect, the extent to which a restriction might inhibit the allaying of public concern. So that's, don't forget, you're supposed to be a public inquiry, but also the risk of harm or damage that could be avoided or reduced by restriction. The most controversial aspect of this part of the Act is that a minister can impose restrictions as well as the chair. So effectively, the minister who set up the inquiry could step in and restrict the disclosure or publication of evidence. But in practice, certainly to my knowledge, that's rarely, if ever, used, and it tends to be the inquiry itself, the chair or the panel, making decisions about what needs to be restricted upon application from the parties. It can apply both to redactions to documents, but also to anonymising witnesses before the inquiry. I'm going to hand over now to Richard so he can address you on the core participant side of things insofar as I've addressed them.
Well, thank you, Emma, and thank you, Riel, and thank you for the invitation to take part in this webinar today. As Riel said, I'm a solicitor at Slater & Gordon, where I head up the abuse team and also our inquiries practice. We have involvement currently in a number of major inquiries, including the independent inquiry into child sexual abuse, ICSA, and the Grenfell and Manchester Arena bombing inquiries. My personal experience of inquiry work began back in 1996 when I was involved in the Waterhouse inquiry into the abuse of children in care in North Wales. That was an inquiry which predated the 2005 Act, and things have changed significantly post 2005, particularly as far as core participants are concerned. Then for the past 5 years, alongside my colleague Kim Harrison, I've been representing victims and survivors in ICSA. And I think in total, we've represented over 100 core participants in ICSA. The vast majority of those have been individual victims and survivors. We've also represented some groups and some individuals who've been granted core participant status because of their specific expertise. So that's my background. Emma has very cogently set out the law. What I'm going to do is pick up on the practical side, and in particular on a few practical issues that arise in representing core participants. And I suppose the most important of those at the beginning is the management of expectations. Most core participants, whether they're ordinary lay people or experienced professionals, will come to a public inquiry never having experienced one before. Unless you're a government agency or a government department, you generally don't get to experience an inquiry more than once. And so entirely understandably, many core participants or people who want to be core participants come to a public inquiry with very little idea of what a public inquiry is, what it can do, and indeed they may have misapprehensions about it. So the first task as a lawyer representing them is to try to clarify expectations around that. And what I've tended to find is that at the point at which the inquiry begins, expectations of what it can achieve are often or can be overinflated. As Riel pointed out, inquiries arise in the context of public concern, and very often the way in which that public concern is mollified initially is by ministers giving the impression that all of the answers will come from a public inquiry, and so you get a lot of rhetoric about leaving no stone unturned and so forth. And certainly in the run-up to ICSA, to give one example, there was a lot of rhetoric about leaving no stone unturned. But of course, in reality, inquiries can't always do everything that the public want and expect them to do. Emma highlighted a key point when she explained that a public inquiry is not empowered to make findings of criminal or civil liability. A public inquiry is not a substitute criminal or civil court. And with ICSA, and this is no fault of ICSA itself, this misunderstanding was a key issue from the outset, particularly amongst the victim and survivor community. Many of them had the impression, and understandably so, because it came from what government and the media were saying, was that this inquiry would actually be putting people on trial. In fact, of course, ICSA's terms of reference are about institutional response to allegations of abuse, and most of the cases examined in ICSA are cases where there have already been criminal convictions of abusers. My colleagues and I had to spend a lot of time in the early days of ICSA reframing expectations amongst our clients about what ICSA was and what it could achieve. And clarity around that from the beginning is obviously very important, but it can't be assumed because of the political rhetoric that often accompanies the creation of public inquiries. An issue which is linked to that is the whole issue of terms of reference. Terms of reference are, as Emma highlighted, probably the most fundamental thing about a public inquiry, and can be even more important than the choice of chair in determining whether an inquiry is ultimately successful. So if any opportunity arises to be part of shaping the terms of reference, that's obviously crucial to take advantage of that opportunity. Boris Johnson has made noises about there being a consultation about the terms of reference of the COVID inquiry. It's not clear whether that will be a formal consultation or not, but obviously any opportunity to shape those terms of reference will be crucial. And again, terms of reference can be one of those things where there can be quite a lot of misunderstanding. In my experience, people who have no prior experience of public inquiries often want the widest possible terms of reference for an inquiry. But in reality, that can be very double-edged. The wider the terms of reference, the less likely it is that any investigation is going to be focused, and the less likely it is that any inquiry is going to be completed within a realistic time frame. And so there's a tension there. And in practice, an inquiry which has very wide terms of reference may simply end up being a lot more selective about the topics within the terms of reference that it chooses to investigate in detail. And that, of course, is precisely what happened with ICSA. The terms of reference for ICSA are incredibly wide. They cover institutional responses to child sex abuse in state and non-state institutions over the past 50 years or so. But obviously you couldn't possibly cover everything within those terms of reference. It would take decades to do that. So what that's meant in practice is that ICSA has had to be very selective about the institutions it examines. And the result of that is that many victims or survivors who thought and assumed at the beginning that wide terms of reference would mean that the institution that they're concerned about or where they were abused would be covered, have ended up being disappointed. There are practical constraints on what a public inquiry can investigate, and wide terms of reference can simply mean more selectivity in what ends up being examined by the inquiry, and sometimes narrow terms of reference can often lead to a more focused and effective investigation. So just to pick up on a couple of the other areas mentioned by Emma, firstly on the question of getting core participant status and what you need to do to qualify for that in any particular inquiry. Emma helpfully set out the legal test for that, and of course that isn't going to change during the course of any particular inquiry. But certainly my experience is that over time, as an inquiry develops and as its investigation develops, an inquiry will sometimes refine its approach to the grant of core participant status. And primarily, I think that reflects the fact that as inquiries do their investigations, they refine and hone what it is that they want to look at. And therefore, their view of who has a significant interest in that investigation tends to be refined over time, and the investigation narrows, and consequently fewer people will then qualify for core participant status. So there's an argument there for getting in early. And of course, the other factor which influences or may influence that is that as an inquiry proceeds, the purse strings tend to tighten. And that can be a factor as well. And that point about purse strings is obviously of wider significance. I may be overstating it slightly, but I think that to some extent every inquiry chair has hanging over them the spectre of the Bloody Sunday inquiry and the risk of their inquiry massively overrunning in terms of time and budget. That's always a big concern for inquiry chairs. Now, that risk has been reduced, certainly, as a result of the 2005 Act. particularly because within inquiry hearings now under the 2005 Act, core participants don't have the automatic right to get up and ask questions. You have to make Rule 10 applications, and Riel will come to that later in this session. But inquiry hearings are now very tightly managed. And so you don't, in a sense, have the same risk of an inquiry running on interminably because of the extent of or length of legal questioning by legal representatives. But of course, cost is still a concern for chairs, and it does undoubtedly influence issues not only to do with the grant of core participant status, but even where core participant status is granted. I think inevitably inquiry chairs will look for opportunities to consolidate legal representation. And particularly where you have a big inquiry with very wide terms of reference and a large number of potential parties, chairs, I think, are going to be particularly interested in looking at the possibility of consolidating representation where they feasibly can. And I can foresee that being an issue, for example, in the COVID inquiry, because there are going to be inevitably a large number of organisations and bodies who will want to be represented in that inquiry. And so consolidation of representation, I'm sure there will be pressures for that. And that's something definitely to anticipate and marshal your arguments around. There's lots more I could say about core participant status, but I think the one other thing to mention, a practical issue, is that it's important to understand that if you get core participant status, that doesn't dictate how much or how little you have to use it. If you get through the door and you get that status, then you've got a whole further set of decisions about what you then do with it and how, to what extent you become involved in the inquiry and in the inquiry hearings. And those decisions are, of course, particularly significant if you're self-funded. If you don't qualify for a Section 40 award and you're funding your involvement yourself, then involvement in an inquiry can be expensive, particularly with huge volumes of documents and so on. And so once you get core participant status, if you're not self-funded, there are some crucial decisions to take about how you use your core participant status. And the key is obviously to focus your involvement in the most effective way. So I'm going to hand back now to Riel to talk about the hearing process.
Thanks very much, Richard. So I am now going to look at the next stages as a public inquiry moves towards the evidential hearings. Those are the things that really the public tend to be the most interested in and aware of. And we'll look at those and what happens after the hearings are completed. The first thing to consider in terms of an impending hearing is the witness selection. As Emma said, the public inquiry will try to identify potential witnesses early on in the investigation and to decide which witnesses might assist with the particular inquiry's questions as set out in the terms of reference, which, as Emma said, can be very wide, and also the scope for the individual strand of the inquiry. That is sometimes a difficult process. Not only are the terms of reference set before necessarily documents and witness statements are in, but the scope is often drafted and set before the actual evidential material that underlies the inquiry is obtained. And the witness statements, the selection process, will also often begin before the statements and relevant documents or records have been received, and before the process of any review of those documents is complete. And that's because hearing timetables are often set up before any material is received. Also because once it's been received, the documentary review is likely to generate more issues. So you have a rolling process of more documents being received, more potential witnesses, and inevitably that will be more than the actual hearing time can accommodate. So counsel to the inquiry, working with the inquiry team, needs to set up an overall strategy for the hearings early on and a process by which to identify the witnesses that should be relied upon. As to that process, it's not dissimilar from a criminal case where an order, a batting order, an order of witnesses is drawn up with the aim of achieving a coherent narrative through the oral hearings, with witnesses being called effectively in chapters that relate to specific topics. The principal difference in a public inquiry from a criminal trial is that you don't necessarily have that advantage of knowing what a witness will say, because you don't necessarily have their statement at the time you make the selection of the witness. And in an inquiry, the chapter headings tend to be much broader, as the timetable generally won't allow for every witness to be called. In effect, as Richard said, you can't cover absolutely everything if the terms of reference are very broad. But that has to be remembered is offset against the fact that a public inquiry is not a criminal trial, and it's not adversarial in the same way that a criminal trial is. So witnesses' evidence is not necessarily going to be subject to the same kind of challenge as it would be in a criminal case. So in terms of live witnesses, when deciding which witnesses should be required to attend and how many, counsel to the inquiry has to bear in mind the overall terms of reference, the scope of the investigation, the time allocated for the hearing, and how the various chapters of evidence come together to form a cohesive narrative. Individuals who give evidence before a public inquiry, it has to be remembered, can come from all sorts of walks of lives. They can be, bishops, archbishops, or higher. They can be victims and survivors, teachers, monks, all sorts of people from different organizations. And the material that they are called to speak about can be voluminous. It can span many, many years, even decades. And so it's important to give any potential witness sufficient notice that they may be required, so that they can make sure that they are available, and so that they can build in sufficient time to prepare. Witnesses are therefore contacted some months in advance of the hearings and are initially provisionally warned. Formal confirmation will generally be sent out at a later date closer to the hearing. There's no specific timetable set out in statute, so the approach from public inquiry to public inquiry will vary depending upon the legal team behind them and the chair. At ICSA, we tried to ensure witnesses were informed that they would be required at least 6 weeks before the hearing, having been given some months' notice that they might be. But sometimes that 6-week, you will definitely be required, information wasn't possible, and sometimes it was cut down to a shorter time span. To help witnesses, applications can be made for evidence to be given over video link, and for vulnerable witnesses to be granted special measures, such as screens, to make the process of giving evidence less traumatic for them. The list of chosen witnesses is circulated to core participants in advance of the hearing, usually have an opportunity to make representations about it, but there is no requirement that their representations or any requests for additional or different witnesses to be called will be taken account of. Really, the reins are held firmly by the inquiry team. As the hearing gets closer, counsel to the inquiry will draft a list of topics that each witness will be asked to cover in the course of their evidence. If any significant topic of interest has been revealed through the document review process, a further statement can be requested from a specific witness to cover it. Again, it has to be remembered it's not an adversarial process, so witnesses are given advance warning of the topics about which they are going to be asked so that they can prepare. At ICSA, we circulated topics to core participants in advance of the hearing, and their legal teams were able to make representations about them, but that is not always the way that things are done. And it will depend very much on the approach that's decided by the chair and the legal team at the outset. In some inquiries, there is no circulation of topics in advance, and representations will not necessarily be invited other than via the Rule 10 process of submitting questions, which I'll come on to in a moment. So that's live witnesses. But like criminal and regulatory cases, witnesses' evidence can be read in full, it can be edited and reduced down to what's relevant, or it can be even summarized. And the approach taken to adducing evidence that way, through reading or summary, can vary considerably between inquiries. Some will read statements into the record in full. Others will edit and summarize passages, and some don't read evidence at hearings at all. The approach to seeking comments for core participants also varies. Some will prepare a list of witnesses to be read with edits and summaries, and then circulate that to core participants for their comments in advance of the hearing. And some don't seek comments from core participants as to content at all. Turning to hearing bundles, as part of the work of reviewing material and preparing for a hearing, the investigation team produces indexes of relevant material that will form the core of bundles for the hearing. Those bundles need considerable thought, as they should contain the statements, all the key documents that a witness will refer to in their evidence, and they should be structured so as to mirror the running order of the witnesses. Again, it's sometimes difficult to do these far in advance of the hearing, as documents may be coming up during they may keep coming in during the days even running up to the hearing, and they may still be being reviewed up until the hearing date. So there's also provision for additional documents to be shown to witnesses on screen if necessary. The hearing bundles will be provided to the chair and the panel, if there is a panel, who will be able to use them to follow along as statements are called or read, and as documents are referred to during the hearings, and they can return to them during their deliberations. They're also provided to counsel for the inquiry to enable them to prepare for the hearing. And witnesses are given the individual sections relevant to their evidence so that they can prepare for the questions that they're going to be asked. The legal teams for core participants will not necessarily be given a full copy of the paper or electronic bundle. The material relied upon will have already been disclosed to them, so they've had an opportunity to see it. But usually before a hearing, they'll be given the index to the documents that will be relied on, and they'll be given links to the documents where they're held on the storage platform, so that they can look them up at any stage and during the hearing as it progresses. I said I'd come to Rule 10 requests by core participants. And based on the witnesses selected and the topics outlined by counsel to the inquiry, core participants can make applications under Rule 10 of the inquiry rules to ask additional questions of any witness. The timescale and the process for making a Rule 10 application, again, can vary considerably, and it's decided by the public inquiry. In the inquiry I was involved in, core participants were required to submit their proposed questions under Rule 10, anything between a couple of weeks before the witness was due to be called to 24 hours beforehand. Questions submitted are then reviewed by counsel. So you can imagine during a hearing, if you receive a list of Rule 10 questions 24 hours before a witness is to be called, that adds considerable pressure to counsel, to the inquiry's team. But then they are considered by the chair, and it's the chair who ultimately makes the final decision on whether or not they think the question is relevant and will assist them, taking account of the evidence that is going to be heard, the terms of reference, and the scope of the investigation. The next stage is the hearing itself. Now, we touched on this already. Every criminal case begins with an opening speech. In a public inquiry, there is no requirement that counsel to the inquiry should make an opening speech, and much will depend on the breadth of the investigation and how much time is available to the hearing. In some hearings, a decision may be made to get straight into the evidence, perhaps because the first witness to be called is one who is going to set the context for the investigation, and their evidence might be repetitive of what would be said in any opening speech counsel might give. My own view, for what it's worth, is that openings in most cases are essential, and they're extremely helpful to the chair and the panel and to core participants and to those observing the proceedings, the public. I mean, these are public hearings, because they set out the narrative in a clear way and they focus attention on the principal issues that are going to be addressed during the hearing and can give reasons as to why certain things are being dealt with and why other things may not be. So I think they're helpful. There are no strict rules of evidence in a public inquiry, so an opening can sometimes be a useful tool through which to introduce evidence or material that's not formally called in evidence. After opening, well, as Richard told you, core participants also have an opportunity and may sometimes make opening submissions. After opening, you move on to the stage of calling witnesses, and generally, most evidence in a public inquiry hearing will be called by counsel to the inquiry. Core participants do not have any automatic right to ask questions themselves or to cross-examine. Whether they'll be allowed to cross-examine will be decided by the chair, but often it's thought to be most efficient for any relevant Rule 10 questions that have been submitted to be adopted by counsel to the inquiry, who then intersperses them into their own examination of witnesses, which means there's less repetition. There's no prohibition when questioning witnesses on leading questions, and counsel to the inquiry can ask questions both in an open and leading way. As the hearing proceeds, there is a rollout, a continual rollout of publication of documents and transcripts. Obviously, as Emma said, public inquiry is intended largely to be public, so hearings are generally publicly open and broadcast. These days, often they're live streamed, usually with a short delay via the inquiry's website. The delay is there in case of a slip up. So for example, if a victim is mentioned by name rather than by the cipher that they've been assigned at the outset of the inquiry, or if there's another risk of breaching their anonymity in some way, the delay on the feed allows counsel to invite the chair to pause proceedings and make a restriction order to cover what has been revealed. During a hearing, a list of documents that are produced during the course of the hearing is kept, including the witness statements that are read, and those documents or the extracts of those documents which have been referred to will be published, usually by being uploaded onto the relevant inquiry's website so that the public can see them. Once all the evidence is called, you move to closing speeches. Counsel to the inquiry does not, in my experience, usually make a closing speech. And this is where the core participants really have their moment. Core participants are allocated a set period of time in which to make speeches, which tend to be a combination of submission, factual analysis, and mitigation on behalf of their clients. I say it's their moment, but the set period of time they're allocated by the inquiry can end up being quite short, and the time allocated will depend on a number of factors, such as the issues the individual core participant has to address, how much hearing time is left, and any other matters that have been raised during the hearing. It's a matter for the chair and the panel, if there is one, to make a decision on how much time is allocated. But if the time allocated appears short, it needs to be borne in mind that core participants can also be allowed to make further submissions in writing. The next stage is what happens after the hearing, and work does not stop. In fact, at that stage, work often goes into overdrive because after the hearing is over, the focus shifts to the drafting of reports. The approach to drafting and who does the bulk of it, again, will vary from inquiry to inquiry. At ICSA, counsel to the inquiry did a large part of it. Whichever way it's done, it's usual for there to be many, many drafts. And regardless of who does the drafting of those initial drafts, each is reviewed by the chair and panel, if there is one, and they are very involved in the process. There are a number of meetings where the drafts are gone through almost in line by line detail, with discussion around any aspect, no matter how small. During the course of meetings, it becomes apparent who will or may be the subject of criticism in the report, and those who may be are entitled to advance warning and are given an opportunity to make representations as to why they should not be so criticized. Their replies are considered, and sometimes the criticism that was going to be made is going to be abandoned. The process of warning witnesses of the fact they might be criticized is done by letter, pursuant to rules 13, 14, and 15 of the inquiry rules. And as I've said, they are entitled to reply and say, I shouldn't receive this criticism because you haven't taken account of these details. And sometimes the criticism will be abandoned. In terms of the final report that is published, the chair and panel direct the views that are expressed throughout the report and the way the recommendations are drafted. And the chair will usually draft an executive summary for the final document. So that is, and I've spoken swiftly because we are already out of time, but we're going to carry on anyway for those who are interested. And I'm going to invite Richard to speak, say a few words just in response to what I've said for those who are staying with us.
Thank you, Riel. I'm conscious we have limited time, so I'll just highlight really a couple of points that I think are relevant to what Riel said from the point of view of acting for core participants. I think the first point I'd make is really to emphasize the importance as a legal representative for core participants of engaging with the inquiry at an early stage. Riel talked about the inquiry having processes for core participants to make representations about things like witness selection, what's going to be investigated, publication of documents, and then as you get close to the hearing, lines of questioning. And obviously there are formal deadlines for that, but my experience of inquiries tends to be that often those things are crystallized by the inquiry legal team some way in advance of the hearing, and it's important to be engaged with the inquiry legal team both formally and informally at that stage in order to be able to influence that process. Emma said in her earlier presentation that in any inquiry there's usually a very long period between the start of the inquiry and the commencement of the formal hearings. And it's during that period that the inquiry's approach to the evidence and how it intends to manage the hearings is going to take shape. If you're not working for the inquiry legal team during that time, it can seem like a very fallow period. But in fact, it's a very important period in the life of the inquiry. And when it comes to things like selection of witnesses and selection of topics, the formal deadlines for responding on that may come later, but the decisions are often made or start to be made, I think, at an early stage. And so it's important as a core participant to be engaged in that both on a formal and informal level. And when I say informal, I mean informal dialogue with the inquiry legal team. And I think the same applies to Rule 10 questions. As Riel explained, that's the process by which you submit questions to the chair. And often that formal process happens very late in the day, but it's useful to sort of begin thinking about that well before that and discussing that with the inquiry legal team. Certainly in ICSA, we had quite a useful informal process well in advance of the hearing where draft Rule 10 questions could be submitted informally to the inquiry legal team, and then there was some dialogue and discussion about whether those questions were likely to be admitted as for questions to be asked in the hearings. And that was a useful opportunity to hone one's approach to Rule 10 questions. So that early dialogue is important. The other thing that I think is worth just commenting on is the whole issue of hearings and how to use them effectively for core participants, and that's undoubtedly a very big challenge in terms, given the way the legislation is now. Following the 2005 Inquiries Act, inquiry hearings are now very tightly managed, and the Rule 10 process is an illustration of that. As a legal representative, you don't have the right to get up and ask questions at will. You have to submit those through the chair. So one of the challenges for legal representatives is, how do you make the most use of the hearing? How do you get visibility for the things that you want to get across? And that will depend, of course, on what you want to achieve and the type of core participants that you're representing. But often, and certainly from the angle that I tend to be coming at it from, which is representing victims, we're very keen, and my clients are very keen, to try to sort of push issues up the public and news agenda. And so the time to do that is always the first day of the hearing and the last day of the hearing, as Riel mentioned. And that also is important because, in my experience, when it comes to the media can be fairly fickle, and sometimes a lot of media will turn up for day one of the inquiry, and some of them will be there for the last day of the inquiry when there are closing submissions. But generally, there are many fewer journalists around during the main part of the hearing. So the first day and the closing day is the opportunity to kind of get your point across in the public eye, and kind of shape the public narrative around what's happening at the inquiry and what you think is important. So that's an important opportunity for core participant legal teams. And those opening remarks are also an important opportunity to read into the record documents. Obviously, documents that are disclosed to core participants within a public inquiry are confidential until the hearing starts. And then once the hearing is underway, they can be referred to by core participant legal representatives, and those opening remarks offer the opportunity to do that, particularly if you want to draw attention to something that counsel for the inquiry hasn't mentioned in his or her opening remarks. It's fair to say that after day one of the hearing, being a legal representative for core participants in a hearing can feel quite frustrating, because even where you've successfully submitted Rule 10 questions, in the main, those generally get asked by counsel for the inquiry rather than by you. So it's obviously important, when they are asked, that counsel for the inquiry credits them to you, because obviously you can then, otherwise you can find yourself in a situation where your clients are sitting there watching and wondering what it is exactly that you're doing all day sitting in this inquiry. So there are certainly some challenges around core participants and hearings, and making sure that you maximise involvement in that way. So those are a couple of the practical observations I'd make about what Riel has said. I don't know how much time we have left, but I'll hand back to Riel for questions if we have any time for that. Maybe we don't.
Thanks a lot, Richard. I think we're over 10 minutes over our slot. So I'm afraid we're going to have to leave it at that. There are a couple of questions on the chat stream, so we'll try and look at those and answer those on the stream. But can I just thank Richard very, very much for joining me and Emma in presenting this webinar. I hope it's been helpful. I hope it's been informative, and I hope it hasn't been too much of a whistle-stop tour of the life of public inquiries. And thank you very much to everyone for attending and listening in to this.